Third Circuit Court for the County of Cheboygan. We are providing public access both in the courtroom and also online. And first up this afternoon, we have it's like an arraignment on two new charges and a status conference on the pending contempts in People v. Brandy Bedell, files 25-7038 and 7039. Counsel, you want to state your appearances beginning with People?
Melissa Goodrich, Cheboygan County Prosecutor.
Brian claimed to have a Brandy Bedell.
All right, good afternoon. And Ms. Bedell is present in the courtroom. Mr. Clayton did obtain the court's permission to Zoom in today. I know you've got another matter you have to attend to shortly in another court. We're here for an arraignment in both files. Have you reviewed the charging document with your client? And do you or she wish to have it read into the record?
We have reviewed the charging document. We need it read into the record, sir.
Okay, and is a forensic center referral requested or appropriate in either file?
It is not.
All right. And does this matter, I know there was some discussion about that. Is this matter resolved at this point, or should we set it for continued docket call?
Ms. Goodrich and I spoke yesterday. We do have a framework of an offer that would be acceptable. However, there was an issue with the bond compliance that we wanted to address today with the court. So I guess we can't do a plea today, but it would be rather short docket to do so.
Okay, I could give you either 2 weeks from today is August 26th. I think you're here, or on September 9th, you're here. So either the August 26th or September 9th. You have a preference?
I'm going to leave that answer to Ms. Goodrich because she wanted to see some bond compliance. So I don't mean to shift. If Ms. Goodrich thinks the 26th would be sufficient to allay her concerns, I could do it on the 26th. I certainly would prefer sooner rather than later.
Ms. Goodrich?
Your Honor, I do have concerns about the request for Ms. Bedell to be released today. So I would ask for the August 26th.
Okay, well, it sounds like you both are couching your statements sort of contingent on what I'm doing on the bond. So why don't I hear from you both on that first? Mr. Clayton, go ahead.
Thank you, sir. The issue on the bond is some dilute tests, and I'm not minimizing that. The court, I think, took notice. I wouldn't say judicial notice because that wouldn't be appropriate. The court did take notice of the concern the court had with regards to dilute urine screens. I'd note there's no positives to be concerned about, but there were rather numerous dilute screens. What I'd like to see is I'd like the court to reinstate the bond for only the following reason: is that Ms. Bedell has demonstrated that she can do better. She has had no positive screens, and she has on the screens that have been negative. They're all appropriate for the protein levels. It's just the dilutes. And since the proposed plea-based resolution, at least proposed, obviously subject to the court's approval, would involve a 7411 assignment. Not to speak out of school with the conversation that Ms. Goodrich and I had, but both of us did express concerns about a 7411 assignment, not wanting to set Ms. Bedell up for failure. And so the tenor and tone of the conversation was if she could get out and perform well on bond, that might at least quell some of Ms. Goodrich's fears about Ms. Bedell being able to perform well on a 7411 assignment. So that's why I'm asking the court to reinstate the bond and allow her to perform at least between now and the 26th without having issues with dilute urine screens. She and I did talk about it and talked about, consumption of, liquids, coffee, things of that nature. I think she can do better. She and I talked yesterday. So I think that would at least quell some of Ms. Goodrich's concerns. And I appreciate Ms. Goodrich's concerns. I'm not minimizing them. I want Ms. Bedell to be successful on 7411 as well. That's my goal. I don't want to do it and then have her not be successful. So that's why I'd like to see if the court would reinstate the bond So she could have, a couple of weeks of urine testing with negative drug results and appropriate protein levels.
Thank you, Ms. Goodrich, people's position.
Your Honor, I'm just concerned about the timeline of this case. It looks like she waived over from district court early June, around June 6th, and then had a dilute screen in this court on June 10th, and then again on June 20th. We offered early July the 7411, but then have received the dilute screenings on July 7th, 10th, 11th, and 15th, which led to her incarceration. On her harboring a fugitive case, that person that she was harboring failed to show in court this morning as well, and so is out on the run. So for all those reasons, I'm concerned with her release at this time.
All right. I mean, when we did the arraignment on the warrant, I went through all of the timeline and the numbers of dilutes and my concerns about all that. But really the thing here is that there were show causes. There were 2 pending show causes for dilute tests that Ms. Bedell surely would have known about. And then she's still out there, submitting several dilute tests, 9 dilute tests within a couple months. That's just an extreme level of dilute test, which means we just weren't really able to consistently test her. And, I've heard testimony from lab people before. I mean, I haven't heard any in this particular case, but, I know from my experience in a treatment court and dealing with testing for years and years that you've got to try pretty hard to get a dilute test. This doesn't just sort of happen to people because they had, a couple sips more water than they should have. And so the fact that they were negative doesn't matter much to me when they're dilute. That's the purpose for diluting the tests, is when you don't want people to be able to adequately test. And if I just have people out on bond on a drug case for, frankly, possessing methamphetamine in a school zone, if I've got some people out on bond for that and I can't reliably test them, and I just say, oh, well, we'll just, cross our fingers. I mean, I did that a show cause, a second show cause, then a warrant. So I am not keen to reinstate Ms. Bedell's bond. She's going to continue to be held without release. I'll have you back in a couple of weeks then on August 26th at 1:30. See what you guys can sort out, or if you don't sort something out, we can set it for an expedited trial if you want. That's no problem.
Your Honor, could I ask the court a question?
Yeah.
And the court doesn't have to answer my questions, obviously, I understand that. But is it accurate that probationers and bond people cannot test until 11 o'clock in the morning? Is that?
I do not know the logistics off the top of my head of the testing hours of the center. So I don't know the answer.
Okay, I just didn't know if you want to talk about it.
What I can say is we have a lot of people on this bond condition in this court, and the overwhelming majority of them do it fine.
Okay.
They do it fine. All right. We'll see you on August 26th at 1:30.
All right. Thanks, sir.